Hello, I am Brian from Seoul Law Group, and we are an English-speaking law firm based in Seoul, South Korea. We're back with another law video, and today we'll cover everything that you need to know about the medical doctor strike in Korea. As part of the government's expansion of medical school admissions policies, it has been decided to increase the medical school admissions from the existing 3,000 to 5,000 for the 2025 academic year. In response, doctors, especially interns and residents, including those from major hospitals in Seoul and numerous hospitals nationwide, have launched collective actions such as strikes. The government announced its position stating that until February 29, 2024, doctors who left their hospital will not be held accountable for returning to their former positions. However, if they refuse to return from March onwards, their licenses will be suspended and legal proceedings will be initiated. This video aims to briefly examine the legitimacy of the medical service resumption order. Punishment of medical professionals, especially interns and residents, is based on the violation of the medical service resumption order under Article 59, Paragraph 2 of the medical law. If the medical service resumption order was legal, medical personnel cannot refuse it without justifiable reasons. If they refuse, they may face imprisonment. In other words, if 1. The medical service resumption order is legal, and 2. There are no justifiable reasons for refusing it, the person who refuses the order becomes subject to punishment. However, at present, medical professionals, especially interns and residents who are not coming in, and it is evident that significant disruptions to patient care is occurring. Is the medical service resumption order justifiable under medical law? Is the medical service resumption order justifiable under medical law? To determine whether it is legal, 4 criteria must be met. First, it is necessary to examine whether interns and residents are not the subject of the medical service resumption order. Article 59 only mentions medical personnel and medical institution operators as subject of the medical service resumption order, without any other restrictions. However, as interns and residents are considered medical personnel, it is clear they are the subject of the medical service. Moreover, upon closer examination of the provisions of the medical law, it can be seen that the government has meticulously prepared for various contingencies. Although not explicitly stated, the phrase suspension of medical service by the medical personnel without any justifiable ground logically presupposes medical personnel who have been providing treatment up to that point. Therefore, interpreting this inversely suggests that the order cannot be issued to medical personnel who have already retired or ceased practice. So, it can be considered that when there were precursors to collective actions, the government issued a prohibition order against resignation to each medical institution under Article 59. So, it can be considered that when there were precursors to collective actions, the government issued a prohibition order against resignations to each medical institution, to interns and residents, before the medical service resumption order. In other words, the aim was to prevent interns and residents from leaving hospitals legally before the issuance of the medical service resumption order. Second, it must be examined whether significant disruption to patient care has occurred due to the cessation of treatment. Given the current situation where even essential staffing is lacking, and patients are experiencing fatal consequences such as death, additional explanation on this matter seems unnecessary. Third, there is no justifiable reason for the cessation of treatment. Indeed, there are virtually no recognized cases where justifiable reasons have been acknowledged. Therefore, at present, there is hardly any room to justify the refusal to comply with the medical service resumption order. However, theoretically speaking, to justify the refusal to comply, it must be considered whether 1. There were insurmountable reasons such as injury, death of a family member, and so on, and 2. Whether the interests pursued by refusing the order outweigh the interests protected by the medical service resumption order. Nevertheless, it appears highly unlikely that insurmountable reasons will be acknowledged. First, medical associations such as Korea Medical Association have been holding meetings to oppose the increase in medical school admissions even before the government announcement and even before the collective actions of interns and residents. There were internal discussions. Additionally, the reasons put forward by doctors as grounds for refusing the medical service resumption order, such as if a flood of doctors from increased admissions in 10 years, the medical system of South Korea will collapse, or if the mandatory healthcare package passes, the medical market will collapse, are abstract and uncertain reasons that may or may not occur in the distant future. However, the risks patients face by not receiving treatment immediately, such as death or permanent disability, are concrete, significant, and foreseeable risks. Fourth, it is also crucial to examine whether the medical service resumption order was appropriately served. This is a crucial element when determining whether various dispositions issued by the government to the public are legal. To understand this accurately, it is essential to briefly examine Korea's Administrative Procedures Act. Generally, the Administrative Procedures Act does not allow delivery online without the consent of the parties. In other words, delivery must be made by mail, and delivery via text messages is not possible unless there are special circumstances. So, there is a rumor that one could evade a medical service resumption order by, for example, pretending not to be home or not answering the door. However, with the experience of the pandemic, a new provision has been added to the Administrative Procedures Act, namely emergency dispositions for public safety or welfare. As a consequence, even if sending a medical service resumption order by mail is not feasible, dispositions for public safety or welfare can be made via text, Kakao Talk, fax, email, and so on. Naturally, this extends to medical service resumption order under medical law as well. Even if the current situation does not necessarily pose a problem to public safety or welfare, if delivery is not made, it can be handled by announcing it on the internet. Well, I hope this video was useful for you. If you have any questions or concerns about the medical doctor strike in Korea, let us know in the comment section below, and you can find more information on seoulawgroup.com. Don't forget to like, subscribe to our channel, and turn on that notification bell for more Korean law videos. And we hope to see you next time. Goodbye.